Shall we start, sir?
Yes, Pooja.
Yes, sir.
Can we start?
Yeah, sure, sir. Let's start today's session by the introduction of our today's speaker, Mr. Divyanshu Agrawal, who is an advocate and practicing in Supreme Court, Delhi High Court, Allahabad High Court, and other High Court, NCLT Appellate Tribunal, Income Tax Appellate Tribunal, National Company Law Tribunal, etc. He is also a fellow member of ICAI. He has 17 years of professional experience and has worked experience with and also has work experience with professional firms like professional firms of very good reputation like EY, PwC, and Deloitte. He also worked in the Chamber of Renowned Counsel of Allahabad High Court, Senior Advocate Shri Rakesh Ranjan Aggarwal. He also worked in the Chamber of Renowned Counsel of Delhi High Court, Senior Advocate Shrimati Prem Lata Bansalji. His experience include rendering advice and representation in the matter of various multinational companies, Indian companies, government undertakings, service providers, non-profit organizations. He has serviced clients covering a wide cross-section of global companies as well as domestic companies in private and public sector. In few matters, the Honorable Principal Bench of NCLT has appointed him as chairperson of the meeting of the shareholders, chairperson of the meetings of the shareholders of the transferee company in terms of direction issued. So it's a pleasure to have you, sir, with us on our platform. Let's all welcome, sir, and sir, it's over to you to start the webinar.
Thank you so much. Thank you, Pooja. Thank you, Arun. Thank you, team educating. Thank you so much for this session and giving me an opportunity to come and discuss the provisions, my experience in the courts on this reassessment proceeding with the members. Thank you so much. The topic for today is intricacies in the reassessment proceeding. As everybody is aware, what is reassessment proceeding? A lot of changes was there in the provision of reassessment. As you are aware that the major changes was done in 2021 in the Finance Act, wherein the complete law has been changed. So what are the changes? What is the implication on the same? How the court is interpreting, when to approach High Court, when not to approach High Court? These are the questions which is in our mind. So let us move further and understand how to handle reassessment notices. So before going into the latest provision, it is equally important to know what was there in the erstwhile law prior to 1st April 2021 when there was an old provision, because I believe many of our members are also handling the matters of the old law also. So it is equally important to know what was there in the earlier law, and then we understand the new law and what was the controversy which happened pan-India in different high courts between the period 1st April 2021 to 30th June 2021, and when the notices was issued, what Supreme Court has informed in Ashish Agrawal, and what was the consequences of that after Ashish Agrawal judgment. So let us go and see what is the background of the reassessment proceedings. Is the screen visible to everybody?
Yes, sir, it's visible.
Okay. So as you are aware that we are reading an Income Tax Act, which is Income Tax Act 1961. So every year this act is amended by a Finance Act. The Honorable Finance Minister every year present a finance bill in the Lok Sabha. After that, passing from the Lok Sabha, Rajya Sabha, and after the assent of the President, it become an act. So since after 1961, every year the budget is, every year the act is amended, and currently the latest amendment was done through Finance Act 2023. Now, what is the history? Let us go to the pre-independence era. This law, Income Tax Act, was Income Tax Act 1922 during the British regime also. Now, the provision which we read 147, at that time it was called Section 34. So Section 34 deals with reopening of assessment before enactment of the 1961 Act. Exactly, it is almost similar to the provisions of 1961 Act. So that is the reason many of the decision of the old Act, it still hold good, and we interpret in 1961 Act. So when then this new 1961 Act was enacted, The old section was split into sections from 147 to 153, which we read as a reassessment chapter. So what was the conditions? As everybody was aware in the earlier law, what the law I am reading is the law till 30. This was there in the Income Tax Act till 31st March 2021, prior to Finance Act 2021. So everybody is aware that recording of reasons to believe is mandatory. So there is a section, subsection 2 in section 148 during those days, which require an assessing officer to record reason to believe. Very important line, reason to believe, a very important weapon in the hands of a taxpayer, which based on which a lot of judgments of the court, which they interpret what is reason to believe. But friends, we'll come to the new law wherein we see that there is no terminology called reason to believe in the new law. So the assessing officer is supposed to demonstrate income, record the reason to believe and demonstrate how the income has escaped assessment. Now, 3 categories were there earlier: 4 years, 6 years, and parameter 16 years. Where reassessment was initiated beyond 4 assessment years, AO was required to come to conclusion that income has escaped assessment on account of failure on the part of the assessee to disclose fully and truly material facts. So friends, as you are aware, you have seen many of the judgments. You know that your case, after filing your return, 143(1) intimation was generated by CPC in every case. And after that, whether your case comes into 143(3) either under limited scrutiny or under complete scrutiny or not. So case 1, in case your case falls into 143 subsection 1, and later on the AO issue you notice under section 148. So this is a case of 143(1) to 148. So in this case, there, even after 4 assessment years, if the AO issue you 148 notice under the earlier regime, we cannot take the pleading of change of opinion. Change of opinion is an issue which we take earlier, that my case was already assessed earlier and on the same material you are coming and again doing my reassessment. So in this case situation, change of opinion principle you cannot follow. Wherein 143(1) intimation was issued, no 143(3) was done, which is a scrutiny assessment. Now, but in the case wherein your original assessment was done under section 143(3), which is a complete or a limited scrutiny, majorly complete scrutiny, and then the AO again issue you a notice under section 148 post 4 assessment years, after 4 assessment years, in that situation, AO has to comply and show that there was a failure on the part of the assessee to disclose fully and truly material facts. This principle was laid down by Honorable Supreme Court in the case of Calvinator also. This principle was laid down in many of the judgments. So I'm just interpreting this particular para. Under old law, 143(1), then you receive 148, and then 143(3), and then you receive 148. 2 different cases are there. But one thing which is very important, whether even after an intimation also, if an AO is issuing you a notice under section 148, he is supposed to show you a reason to believe. Some information which he receives wherein he has to apply his brain, live link the connection, and then he has to generate a reason to believe before issuing you a notice. But Income Tax Act has a lot of checks and balances. So after recording the reason to believe under section 148 subsection 2 and before issuing notice under section 148, assessing officer is supposed to take a sanction under section 158 from its superior officers, valid sanction. And if the valid sanction is missing, obviously there are a lot of cases wherein the assessee has challenged this particular issue before a high court under writ jurisdiction, and High Court has quashed the notices because there was a lack of sanction under section 151. Now, what was the time limit for issue of notice in the earlier law? 149 was a section which provided the time limits for issuance of notice could be either 4 years or 6 years or 16 years. 16 years was a period for foreign assets, undisclosed foreign assets. So there was a provision of 16 years from the end of the assessment year. 3 time limitation was prescribed in the law till 31st March 2021, wherein the notice was issued till 31st March 2021. Now, after complying with the statutory requirement, AO was required to issue jurisdictional notice under section 148, intimating the assessee about initiation of reassessment proceedings and directing filing of return of income. So at the time of issue of notice, when you see 148 notice, These days, everybody is aware it is mandatory to have a DIN number on this 148 notice. So whenever you receive 148 notice, you need to see the notice properly and see whether there was a DIN number generated or not. Now we have even have a Delhi High Court judgment in the case of Brandix, which says if the DIN number was not generated by the AO, so automatically this notice become invalid. So you need to see whether the DIN number is generated or not, who has issued the notice, whether the jurisdictional assessing officer has issued the notice or not, and who was the sanctioning authority. At the bottom it is written who was the sanctioning authority. You need to see all these things in the notice whenever you receive notice. So as soon as you receive a notice, there was a time period prescribed. Earlier, it was the time mentioned in the notice, which is 30 days. 30 days was a time specified, or less than 30 days was a time specified in earlier days prior to Finance Act 2023. So now, what was your right? There was a judgment pronounced by Honorable Supreme Court in the case of GK and Drive Shop. GK and Drive Shop has laid down the procedure which you need to comply whenever you receive notice under Section 148. As soon as you receive notice under Section 148, you are supposed to file your return within the time limitation specified in the notice. And after filing your return, you are supposed, the mandatory condition is to write an application to an assessing officer and requesting him to provide you a copy of the reason to believe and all the material which is available with him, based on which he come to a conclusion of escapement of income. So as soon as he gives you a copy of reason to believe and the material which is available with him, then you have to file an objection against that. If you have some issues with that particular reason to believe, you need to supposed to file an objection against the same. And as per the law, it is mandatory for the assessing officer to dispose of your objection via speaking order before proceeding further in a reassessment proceeding. These were the terms and conditions which you're supposed to comply. Now the question comes, if the AO passes an order which is not acceptable to me, when do I go to the High Court, knock the door of a High Court under writ jurisdiction and challenge that particular notice? Very good question. Friends, the right time for you was to file when the AO passed a speaking order disposing your objections. That was the stage. If you are going and invoking a writ jurisdiction and filing a writ only at the stage of a notice, then definitely there is a high probability that the jurisdictional High Court will dismiss your writ petition by saying that you have not complied with the Honorable Supreme Court direction in the case of GK and Drive Shot. First comply with that, and then if you still not satisfied, then come to me. So the right point wherein you need to invoke writ jurisdiction and go to a High Court, knock the door of a High Court, is after receiving an audit disposal objection order. If you're not satisfied whether they have categorically dealt with your case or not. One thing which is very important, everybody, whenever you receive 148 notice, please see DIN number is there or not, sanctioning authority was there or not, whether they have sanctioned or not, what is the time period specified in that particular notice, you need to comply or file your return within that. After that, whenever you receive a reason to believe copy, see what information is given in the reason to believe properly. If AO is relying on any material, if he has not supplied you that material, ask him that to please supply me the material based on which you have designed your reason to believe. That is important. And not only this thing, if you relies on any third party statement by saying that the third party has allegated that you being a beneficiary of some transaction, then ask him to provide you a copy of that third party statement. And if he's not supplying you that, write it down in your objection disposal. Am I again repeating, friends? Write it down in your objection. And in case if you don't deal with that objection, then that is the right time to trigger your writ jurisdiction and to go and knock the door of a High Court, taking this position. So as I've already mentioned, order disposing of legal objections. If legal objections were filed by the SC, AO prior to proceeding with the reassessment was required to pass separate speaking order disposing of the legal objections. If adverse, assessee was at liberty to challenge the same, invoking writ jurisdiction of the Honorable Jurisdiction High Court. Now, very good question which many people raises from me, Mr. Agrawal, how I determine the jurisdiction High Court? Very good question. Friends, if you need to see who is an assessing officer. What is the jurisdiction of an assessing officer? The jurisdiction of an assessing officer determines the jurisdiction of a High Court. If the assessee AO is based in, the person who has issued your 148 notice is an AO based in Delhi, that comes under the jurisdiction of Delhi High Court. If it is Noida, Greater Noida, Ghaziabad, comes under the jurisdiction of Honorable Allahabad High Court. If it is Gurgaon, Faridabad, Manesar, comes under the jurisdiction of Punjab and Haryana High Court. You need to determine based on the jurisdiction of an officer who is issuing a notice under Income Tax Act. So this was also confirmed by Honorable Supreme Court in a decision called ABC paper, wherein they have categorically mentioned how you determine your jurisdictional high court. Now, after this, now the AO then start issuing you 143 notice and then 142(1) notice. The AO was required to conduct necessary inquiries and finalize the assessment after taking into account the response of assessee. Assessment order was required to be passed within the time period provided under section 153 of that. Friends, this is the stage. Every notices you receive, you have to be very clear at what stage you are triggering what. If you miss a bus, it is now difficult for you to go and again take the ticket of your bus. I'm again repeating. After objection disposal, go. If you're not convinced, file a writ jurisdiction, invoke a writ jurisdiction, file a writ before the jurisdictional high court and take those pleadings in your writ jurisdiction, in your writ. In case if you miss the bus and they have started the process after passing an assessment order, it is very difficult to go in a writ jurisdiction until a certain conditions as defined by the Honorable Supreme Court is there. Once an assessment order has been passed, obviously you have an alternative remedy of filing a first appeal. So maximum cases, the Honorable High Court usually they dismiss your petition on the ground of an alternative remedy. That depends on facts to facts. If there is a jurisdictional flaw, then yes, even after passing an order, you can go and challenge that order in a writ jurisdiction, like in the case of notice issued in the name of dead SSE 148. In spite of that, you have already informed the assessing officer that the person is no more, passed away. In spite of that, if a person issued a notice, yes, that case you can take up before the High Court even after the passing of an order, or any of the cases like these days is a faceless assessment provision going on. As everybody is, if you're writing and asking assessing officer to provide you an opportunity for hearing, but the assessing officer is not giving you an opportunity of hearing, without giving an opportunity of hearing, he is passing an order, or without considering your reply, he is passing an order. That is a stage wherein you go and invoke writ jurisdiction and go and knock the door of an honorable jurisdictional high court. Otherwise, maximum cases after passing of an assessment order, being an alternative remedy available, maximum cases depends on case to case. The High Court doesn't interfere into that order. I have already discussed this GK and drive shot. This is reported in 259 ITR 19. Certain points which is important for you. The assessing, these were the provisions which is relevant in the arrest while law. Why I'm repeating arrest while law? Because many of the cases must be your handling wherein the notices was issued till 31st March 2021, maybe which is at the stage of first appeal or maybe at the tribunal level or above. The assessing officer has to record the reason. This is very important for taking action under section 147. Recorded reason must have a live link with the formation of the belief. Jurisdictional condition under section 147 is the formation of belief by the assessing officer. Now you see many of the cases what happened. Some investigation officer has given a notice or an information to your jurisdiction Leo, and based on that the jurisdiction Leo record the reason to believe. No, that is completely a borrowed satisfaction. Any information received by an assessing officer is not sufficient. He or she has to apply his or her brain, understand live link, formation of a belief by your jurisdiction Leo, and then record the reason. This is the way he has to go with that. He cannot blindly follow any information which he received and record his reason blindly and just issue a 140. No, that is a case of borrowed satisfaction, which is not acceptable. Even that becomes the notice become null and void if completely relies on third-party information without application of his mind. No action can be initiated under section 147 after the expiry of 4 years. This is applicable in only those cases wherein original assessment has already been conducted under section 143.3 and again AO is issuing you 148 notice after 4 years. But yes, this case the AO can take this position only when AO has some fresh material. For example, some search happened which was not there at the time of original assessment and some new material has been in the position of an assessing officer and something triggers in his mind. Then obviously based on that material, he can reopen the case. But some fresh material, which is a mandatory condition in this provision. certain issues. Maybe these were the issues based on the judicial pronouncements which you come across. Maybe regularly you're coming across with these points. Now, one thing which is very important, which a lot of taxpayers have challenged in a writ jurisdiction in High Court, or maybe in an appellate jurisdiction before first appeal or second appeal, or maybe at the High Court under 260A, they have taken this position. Reasons have to be recorded prior to issue of notice. 148 subsection 2 of the earlier erstwhile provision says, many of the cases we have observed that notice was issued on 29th March, reasons was recorded on 30th March. Null and void, invalid notice. This is mandatory to be recorded prior to issue of notice. AO to disclose and open his mind through reason recorded by him, as already discussed by me. Reason recorded should be communicated thereof to party concerned within a reasonable time. Now, if you are consistently asking for reason to believe and he is supplying your reason to believe maybe post after passing an assessment order, no, that is not acceptable. He has to supply your reason to believe within a reasonable time. Actual reason recorded should be communicated. I have already covered this thing. Reason recorded should be self-explanatory, wherein you can very clearly analyze what document, what information he has with him, how he applied his mind, what he has inquired, and based on which he is coming to this conclusion. Now, what happened? Many of the cases we have seen, the reason to believe was something else. At the time of argument, the learned standing counsel of the revenue takes a different position by filing an affidavit in an high court, by saying a different position, or maybe say, I must say they are improvising the reason to believe. This is not acceptable. So you cannot put your brain and improvise the reason to believe. If you are taking something, the reason to believe should be an original reason to believe, which was before the assessing officer. Now, if take an example, AO writes this thing that this is the information I've received from Mr. X, and based on the inquiry by Mr. Y, I've come to this conclusion. Is not correct. The AO, the jurisdictional AO, is supposed to apply his mind and form a reason to believe. Notice issued by the AO who had no jurisdiction. Reassessment is bad in law. Your assessing officer is what 212, so and so city. Issued by 211, which is not your jurisdictional AO. Reassessment is bad in law. That is the reason I'm again repeating. Whenever you receive notice, please see every point carefully. Any gap that helps you in your case. Tangible material would mean that it is sufficient, bona fide, definite, relevant, and reliable. Any material, that is the reason I'm saying, whenever you ask for reason to believe, ask him for material also. Whatever material he has. And if he not supply you, take it in your objections. This pleading. Now, what happened? The AO is transferred. Mr. X is a person who has a reason to believe, and Mr. Y, based on the reason to believe of X, has issued you a notice. No, this is not acceptable. Same person has to issue a notice who has applied his mind and who has a reason to believe. These are the judicial. I have taken these ratios from the judicial pronouncements only, friends. So there is a lot of judgments which covers those areas. Recording or requirement of law is reason to believe and not reason to suspect. So reason to believe, again repeating, this is important, not reason to suspect. I'm again repeating. 148 notice you receive, check whether the jurisdictional AO is your AO or not. Number 2, whether the DIN number is there or not. You have a Brantix judgment of Honorable Delhi High Court. Number 3, whether the sanctioning authority is correct or not. Earlier law, within 4 years, JCIT, additional commissioner, more than 4 years CIT. Within 4 years, we have seen many of the cases I have addressed wherein the CIT has given a sanction within 4 years, which is not acceptable. Even with between 4 to 6 years, I have seen a lot of cases wherein instead of CIT, JCIT has given an approval. Wrong sanction, invalid notice. How much time specified? Reason to believe, you ask for a material, you ask for third-party statement on which he is relying, and then based on all those papers, file your objection. This is a complete case of reason to believe, and this particular word is now deleted from the system in the new provision. I'll come to that also. Notice issued on the ground of factually incorrect position. Now, what happened in your case? The taxpayer has sold a shares of XYZ Private Limited at so much price. This was the information based on which the notice has been given to you. But you know that this is not the fact in your case. You have not sold. Take an example. Instead of X company, you have sold Y company shares. Different number of shares, different valuation. This is incorrect facts. Reopening is bad because based on the wrong facts, the AO has issued you a notice. Wrong facts. That is the reason, once you have a reason to believe, you see and get, maybe you draft or get it drafted from an expert. The objection is very important document. This is a foundation of your complete case. Maybe you fight your case till the stage of top level apex court, but that foundation is, you have to set up at the stage of an objection when you draft an objection and file your objection. Now, if sanction is not obtained, they should be highlighted in the objection. If you believe, like what I have already discussed, within 4 years, sanctioned by CIT, between 4 to 6 years, sanctioned by JSCIT, wrong authority. If you believe that is a wrong authority, take it in your objection. And if the AO is not addressing those points and disposing of your objection, highlight those points before Honorable Jurisdictional High Court in a writ jurisdiction. Again, a very interesting case. Notice issued on 30th March, say 2021. Sanction obtained on 30th March 2021. Notice was issued at 5:50 p.m. Sanction obtained at 5:40 p.m. How is it possible? Or maybe, and so you need to see what is the time duration. If the sanction authority is only recording satisfied, fit case, no, it is not possible. No application of mind. You need to challenge those sanctions. Now, what some of the judgment says the AO should give sufficient time to assessee after disposal of objection, at least minimum 3 to 4 weeks, so that if an assessee wanted to challenge those objectional disposal order in a writ jurisdiction, he can go and pursue that remedy which is available with him. But this is not in the statute. It depends on AO to AO. AO can follow, AO cannot follow. Merely acting mechanically on the information supplied by the investigation wing issuing notice would be invalid. As I've already discussed, once you have, these are the checkpoints which you have to see. Once an assessing officer has an information, now what he has to do? These days, what is happening? You're not attaching any documents. He has to see all the clauses of the return which you have filed. If your case comes into tax audit, he has to see the tax audit report, because in tax audit report, he also attached the balance sheet P&L extracts. If your case is into international transaction, he has to see what 3CB is uploaded. He has to have all the documents on the system. He has to match each and every document. And if he find some information is with him, but that particular information is not disclosed in the return, and not only that, he has to do other investigation, like he is supposed to issue 133(6) notice to third party. Maybe if they are saying that you have sold particular X company shares, he issue a 133(6) notice to that company to verify whether the particular person is a seller or a buyer of the transaction. If he has done whether he has done every aspects or not, or he is blindly following an information which he is received. So friends, if he has not done any exercise, he just blindly follow the information which is received, this is a case of borrowed satisfaction. You can file challenge, take it in your objection, challenge it in case if it doesn't address those things, challenge it in a writ jurisdiction in a high court. So reason to believe is a safeguard point given to a taxpayer. The reason to believe has a wider meaning. Many of the courts has analyzed the reason to believe. Even the Honorable Supreme Court has analyzed reason to believe. What is reason to believe? Now, you remember earlier what happened? A question, second last bullet, if you see, earlier one I have already covered. Date of issue would be date on which notice is handed to postal authorities. Now, what happened earlier? You receive notices via post. Latest, you receive everything on an email, not via post. Earlier, what happened? You receive notices via post. So, provision doesn't talk about service. Provision talks about issue, obviously subject to service. So, in case if on 31st March 2021, he issue you a notice and you receive notice on 7th or 8th of April. So what is more important is to see whether he issue a notice and he's given that notice to the postal authority on the same date or not. Because in case if he given that notice on a postal authority, that becomes uncontrollable situation in his hands. He cannot control those situations. That we count it as an issue. But take an example, he issued a notice on 31st, but handed over to the speed post guys of the department, speed post people on 1st of April. That means that notice is time barred. As per the provision, if you see, if it is a time barred notice, then it becomes a time barred. Issue is very important, which you have to see. So once you receive an earlier, what happened when you receive an envelope, you always take out the speed post tracking details and check when they have issued you a notice. Service is important. In case if they issue your notice, but it has not been served, invalid notice. Service is equally important. This is a case wherein the case was wherein original assessment was done under 143.3 and after 4 years, AO issue you a 148 notice, which we have already discussed. AO is supposed to show a failure on the part of the assessee to disclose fully and truly all material facts. Whether you have, so this is very important, but this is only applicable in the case of 143.3. After that, 148. If it is a clear-cut case of intimation under section 143.1, it is squarely covered with the judgment of Rajesh Jabri pronounced in 2007 by the Honorable Supreme Court. That this change of opinion you cannot trigger in the case of 143.1, then 148. It is covered by Rajesh Jabri pronounced in 2007 by Honorable Supreme Court. So there is no bar for reopening of assessment more than once. 8 times, 6 times, assessing officer can issue you 148 notice subject to all the conditions of 148. If issue raised in second reassessment was part of original assessment, then second reassessment was held to be invalid. So same thing, if they have particularly, or this is a case of 143.3 and then 148. If they have raised a query in an original assessment and you have responded and you are satisfied without talking anything in an assessment order, then later on again, if subsequent AO issue you another 148 having the same query, then this is a case of review. Review is not allowed. Now, questions relating to jurisdiction which goes to the root of matter can always be raised at any stage. So jurisdiction means wrong assessing officer issuing notice, that is a jurisdictional flaw. Wrong approval by wrong sanctioning authority, that is a jurisdictional issue. Reason to believe not there, that is a jurisdictional issue. This you can take it at any stage. At the case, in case if you misses this point at the time of first appeal or at the time of assessment stage, you can take it in the stage of first appeal or second appeal using a judgment of Honorable Supreme Court in the case of NTPC. Legal position you can take as in the form of filing an additional grounds of appeal before the first appeal or second appeal or maybe a high court under section 260 appellate jurisdiction. Now 292 BB is a section which says if you have not taken any position and you have participated in a proceeding, you're not supposed to take those positions if not raised in the assessment proceeding. So if 292 BB we talk about, 292 BB, there is a proviso. This the department always takes against you. So there is a proviso which says nothing contained in this section shall apply where the assessee has raised such objection before the completion of such assessment or reassessment. If you have taken any position in an assessment proceeding, in spite of that you being participated, whether AO has addressed those concerns or not, you come into the proviso of 292 BB and you can again take those positions at any other level. So as I've already discussed, friends, a lot of judgments pronounced on the concept of reason to believe. 63 ITR 219 Supreme Court, 130 ITR 1 Supreme Court, and then again 236. A lot of these are the Honorable Supreme Court judgments wherein they have analyzed what is reason to believe. Same thing, fishing and roving. You know what happened earlier? I believe you all have an experience when there was no concept of DIN. DIN was introduced very later. What happened? A lot of time what happened, the AO without recording the reasons, they issue you 148 notice just for the fishing and roving inquiry to get some information so that at least they meet their targets and issue your notice and get some information from you. So reassessment proceeding doesn't give power to AO to do fishing and roving inquiries. Judgment. This is a very landmark judgment, 2010 judgment, CIT versus Kelvinator of India Limited. There was a full bench of Honorable Delhi High Court which pronounced this decision, later on confirmed by Honorable Supreme Court. The judgment says, review of an assessment in the guise of reassessment proceedings was barred, being an inbuilt and inherent check on the arbitrary exercise of power of reassessment by AO. Concept of change of opinion was to be read into the reassessment scheme. Very landmark judgment, Kelvinator of India Limited, reported in 320 ITR 561. Then another very good judgments, valid sanction under section 151 and inbuilt check on the wanton exercise of powers under section 147 cannot be reduced to mere formality. That is the reason, friends, what I am saying. Within 4 years, sanctioning authority in the erstwhile law was JCIT or additional commissioner. 4 to 6 years, it was CIT, DCIT. Many of the cases, you have observed that the wrong person is giving a sanction. Flaw, jurisdictional flaw. You come and you have a full right to challenge it in an objection and later on in a writ jurisdiction or in an appeal. Furnishing of reasons to believe, sanction under section 151 and relied upon documents, information, evidence to assess mandatory. This is coming from G.K. Drive Shop, one judgment of Honorable Delhi High Court sub-infrastructure, wherein the Honorable Delhi High Court is given a direction how to handle that 148 proceeding reported in 398 ITR 198 and then Tata Capital Financial Services Limited. This is a writ petition before Honorable Bombay High Court. Then order disposing of the legal objection amenable to challenge. As I have already discussed, as this is the right point wherein you can trigger your writ jurisdiction and can challenge this order. Reported this position was coming from 390 ITR 1 Supreme Court, Jeans Knit Private Limited and Garden Finance Limited, Honorable Gujarat High Court decision of 268 ITR 48. Friends, now I have covered what was there in the pre-existing provisions. Erstwhile law. Erstwhile law means any notices issued till 31st March 2021. Probably you are handling those cases at the level of first appeal or second appeal tribunal or maybe High Court, 260 or maybe Supreme Court. So these always helps you. These were the issues still alive in the old laws. Now, let me come to a story. As everybody is, before coming to this slide, as everybody is aware what happened on 15 March 2021. 24th March 2021, lockdown was announced by Honorable Prime Minister. There was a lockdown for 3 weeks because of Corona. So there was an ordinance issued called TOLO, Taxation Ordinance Law. What do you mean by ordinance? There is a power given to the Honorable President of India via Constitution of India, wherein when both the sessions of Parliament is not running and something very important, urgent need, you are supposed to take the position, you can do it in the form of an ordinance. So TOLO was passed, which was confirmed via TOLA in September 2020. Ordinance Act, which is we usually called Relaxation Act, which gives a lot of time extension because the disease was deadly disease. So a lot of time was extended. So during those period, time was extended, all these notices, compliances was shifting. A lot of notification has been issued. So through Relaxation Act, the government has given a power to the CBDT to extend the time limitation. During those period, the government, the Revenue Ministry is working on the new budget, which is 2021. At the time of Honorable Finance Minister's speech in the Lok Sabha, categorically, a lot of things has been changed. From 6 years to 3 years, law has been changed. The figure was, threshold was, limit was fixed to 50 lakh, less than 50 lakh, more than 50 lakh assets. This provision is supposed to come into picture from 1st April 2021. Honorable President of India has given an assent on the consent on 28th of March 2021. Now the issue raises. Because after passing the act, this section comes into picture. Now, many of the assessing officer was working from home. And that was the period, if you remember, the second COVID hits. And that was the most deadliest time. Many of the AO was actually working from home. They have started issuing notices. A lot of things happen. Notices were issued dated 31st March 2021 later on. But if we see the record, the notices was issued actually after 31st March. So there was a notification issued wherein via an explanation, the CBDT tried to stop the clock and travel beyond the new legislation. They tried to invoke the old law till 30th June 2021, though the Parliament has categorically informed that the new law is going to come into picture from 1st April 2021. This was the litigation. I'll cover those litigation part later on, which helps you in understanding the new provision. Let us see what is the background. What was the new provision inserted in the statute, which was effective from 1st April 2021. The legislature, via the Finance Act 2021, completely revamped the scheme of reassessment by substituting the provisions of section 147, 148, 149, and 151, and introducing new procedure to be followed before issuance of notice under section 140. So friends, these days what you are reading in the Income Tax Act is a new provision, which is effective from 1st April 2021, followed by an amendment by Finance Act 2022, followed by amendment by Finance Act 2023. So sunset clauses were inserted in section 153A and 153C. In this regime, as you remember in the search chapter, prior till in 2003, there was a section introduced called 153 ABC. Prior to that, it was a block assessment. So from this, the 153 ABC concept has been replaced. In the period, any search done from effective from 1st April 2021 under section 32, 132, 132A. So new reassessment scheme came into effect from 1st April 2021. Now friends, 148 has been completely substituted to provide that reassessment proceeding can be initiated under section 148 when there is information with the AO. Information word is very critical, which suggests that income chargeable to tax escaped assessment for the relevant year. Now friends, you see no reason to believe now. Reason to believe gone in the new provision. So now they are stressing on information. You must have an information. Then only you go for invoking 148. Now the question comes in our mind, what do you mean by information? A lot of litigation in the courts on information definition. Information for the purpose of section 148 has been specifically defined in explanation 1 to mean any information in accordance with the risk management strategy of the board. I believe it is more easier for you to understand. You remember whenever you open a site, you receive a notice from Insight Portal. So Insight Portal is nothing, which is called a risk management strategy. Any information flagged in accordance with the risk management strategy of the board, any audit objection that assessment has not been made in accordance with the provisions of the Act, any information received under DTAA, which is double taxation avoidance agreement, they receive some information from Cayman Islands or Mauritius or Singapore or some from other country, wherein they find some transactions which you have, the assessee has done, but he or she is not, or the company is not reporting in its return of income. Any information being made available to the assessing officer under the scheme notified under section 135A. Any information which requires action in consequences of an order of a tribunal or a court. Fortunately, one of my colleague has an order which fortunately that converts, unfortunately for the taxpayer, it's converted into a tax proceeding based on this information. The last layer was any information which requires action in consequences of an order or tribunal or court. What happened in this case? There was a family court decision wherein during this, prior to a demonetization period, husband has given at the time of a divorce, in the form of a maintenance, husband has given around 1 crore rupees to wife in the form of a cash. And that was recorded in the order. Now what happened? The wife report to the income tax department that my husband has given me 1 crore rupees, giving the income tax authority the copy of the order. So friends, based on that, income tax has issued 148 notice to the husband. What is the source of this money? Try to relate. Clause F. Any information which requires action in consequences of a tribunal or a court. So based on the order of a family court, wherein the husband has given 1 crore to wife, that order become a base of an information for the assessing officer, and based on this information, the assessing officer issued a 148 notice to the husband asking for the source of income of 1 crore rupees. This is what tribunal or a court. Any information, any details which is coming from any laws, anything wherein you have deposited something, if income tax officer comes into handy that order, maybe somebody has informed the income tax department, that also can be a part of an information for the department to issue 148 notice. Prior to issue of notice under section 148, AO is required to follow the procedure prescribed under section 148A and pass an order under section 148AD. Now what happened? GK and drive short judgment pronounced by Honorable Supreme Court long time back was never a part of the statute. So when you observe, irrespective of the decision pronounced by Honorable High Court, jurisdictional, or Honorable Supreme Court or Honorable Tribunal, assessing officer never follows those things. They always say that we wanted to keep the issue alive. We are in the process of filing an SLP, or we are in the process of filing an appeal before the High Court, and they keep the issue alive by keep doing addition in your subsequent assessment years. This time in the new law, the government has inserted the GK and drive shaft direction in the statute. So they have categorically inserted a section called 148A by saying that AO, before issuing notice under section 148, is supposed to comply with the procedure given under section 148A. A has 4 legs, A, B, C, D, which are the clauses. Earlier, what happened, friends? Earlier, AO issue you a notice, you file a return, you request for reason to believe, they supply you reason to believe, they supply you material, they supply you statement, you file objection, they dispose of the objection, you decide whether to challenge in a writ or not, and then you continue with your assessment proceeding, and then this was a procedure. Now, before issuing 148 notice, AO will give you 148A clause B show cause notice. After clause B show cause notice, they give you a particular time period. You are supposed to file your reply within the time period, which is, and they consider your reply in the material C, and then they pass an order under section 148 clause D after taking an approval of the sanctioning authority. And along with the order, they send you a 148. So a lot of checks and balances has been inserted in the new provision prior to issue a 148 notice. So let us see what does section 148A. And friends, for every line, please read it with me, because every particular point is crucial. There are a lot of litigations pan-India going on in every point. AO under section 148 is obliged to conduct inquiry with the prior approval of the specified authority with respect to information which suggests that income of the SC escaped assessment. So clause A says, as soon as the assessing officer has an information, he is supposed to conduct an inquiry. Friends, earlier what happened? Earlier there is a concept called reason to believe. This time the concept is information. In the reason to believe, AO, after having an information, has to do an inquiry, formation of belief, link, and then issue you a notice. This time, after having an information, they are supposed to conduct an inquiry. They cannot blindly comply with the information only. They are supposed to conduct an inquiry, which is a part of clause A. Clause B. Issue a notice upon the SC to show cause why notice under section 148 should not be issued and provide an opportunity to being heard to the assessee, which is given in clause B. I believe everybody is aware about clause B. Many of them have already have received show cause notices since last 2 years, starting from 22, 23. They have received show cause notices. They specify your time. Friends, there are a lot of civil laws judgments which talks about, have you observed many of the lengthy show cause notices? Maybe you have addressed transfer pricing also. You receive a lot of lengthy show cause notices and you are supposed to reply in 48 hours or 24 hours. Some judgments of the civil law also say, CPC also says that at least give minimum 7 days time to the concerned person to file a reply. This time, this was inbuilt in the statute. Time period of at least 7 days, but not exceed 30 days. Now, few of the cases we have addressed wherein 3 days and 4 days time was given. We challenged those orders in a writ jurisdiction and court has remanded the matter. Court has quashed that notices and set aside the matter back to you to give minimum 7 days and again consider the reply. So minimum 7 days time is important as per the statute, but not exceeding 30 days to respond to the show cause notice. But 30 days means you move an application and requesting the assessing officer to give more time. Otherwise, assessing officer is supposed to give you only 7 days time to file your reply. Consider the reply. Friends, please see, I have shared the judgment also. Please see Minu Shafla 445 ITR 0001. Consider the reply. The AO has not considered my reply. It categorically says that was a judgment wherein when we receive 148 clause, judgment was pronounced in May 2022. As soon as 148 clause B was issued, AO, the assessee has moved an adjournment application requesting to give some time, a time for 2 weeks. The assessee is supposed to comply within 7 days. The AO closed the portal within week in spite of moving an adjournment. When the assessee observed that the portal has already been closed, assessee has sent all the documents on an email. After an email received, the assessing officer has passed an order under section 148D without considering the reply. We challenge that thing in a writ petition. First of its judgment of the High Court in the new law. We challenge those decisions in the High Court. Honorable High Court has quashed the notice, set aside the matter back to AO to consider the reply and then passed a detailed speaking order. 445 ITR 0001. So that is a power of reply. If the AO is not considering your reply in spite of you filing, after getting 148D order, 148D order is the same order like earlier it was objection disposal order. You trigger, you invoke writ jurisdiction, move in judgment. In the same position, you find Meenu Shofla, same position, you find Popular Medicos. There are a lot of judgment which is already reported in ITR. And you can, I have already shared few of the judgments. You can take and see those judgments. Wherein the assessing officer has not considered the reply, Honorable High Court has quashed the notice, remanded it back to you to consider the reply. Now D says decide on, please see, decide on the basis of material available in record and the reply furnished by the SC. By passing an order within 1 month of receipt of assessee's reply, whether or not it is a fit case for issue of notice with prior approval of specified authority. Now, friends, 148 is not applicable in the cases of search requisition initiated or made on or after 1st April 2021. Issuance of jurisdictional notice under section 148. So once the mandatory procedure set in section 148A is undertaken, the AO shall issue notice under section 148 along with the order passed under section 148A clause D if applicable. If applicable, why? Because in such cases 148D is not applicable. Requiring the assessee to furnish within a prescribed time its return of income for the relevant period. Now, it was a prescribed time, friends, earlier. Now, if you read after Finance Act 2023, it was already amended. After Finance Act, instead of prescribed, a word written was a period of 3 months from the end of the month in which the notice is issued. So the government has given more time now. This is the amendment made in 148 in White Finance Act 2023. So when you read it categoric, instead of prescribed time, now the time period is given 3 months or further time period as you move in application. But depends. But 3 months is not applicable in the case. 3 months is applicable for any case effective after the application of Finance Act 2023. Earlier, it was still the old laws. Completion of assessment, reassessment. After filing of the return, the assessment proceeding thereafter shall be carried out in terms of section 143(3) or 144 of that, as the case may be, and the order completing the reassessment shall be passed within the time limit prescribed under section 153. Explanation 2 to section 148 provides that in case of search, survey or requisition initiated or made on or after 1st April 2021, assessing officer shall be deemed to have information which suggests that income chargeable to tax has escaped assessment. Now, friends, what is the time limit? Time limit is given in section 149. I'm just, not only I'm running the slides and discussing the matter, I'm just flipping the pages of my Income Tax Act also. So time limit for issuance of notice under section 148. In terms of section 149, notice under section 148 can be issued within 3 years from the end of the relevant assessment year. Now, friends, when this Finance Act 2021 was triggered, it was triggered on 1st April 2021. So you have observed a lot of assessment year 18-19 cases, 19-20 cases. So now what happened? Earlier it was 4 years minimum, then 6 years and 16 years. Now the time limitation specified is now 3 and 10. You have a 2 barrier, 3 and 10. Within 3 years from the end of the relevant assessment year, or within 10 years from the end of the relevant assessment year, where the AO has in his possession books of account of the documents or evidence which reveal that income chargeable to tax which has escaped assessment amounts to or is likely to amount to 50 lakh or more for the said year and is represented in the form of an asset, expenditure in respect of a transaction or in relation to an event or occasion or an entry or entries in the books of account. So if it is less than 50 lakh, within 3 years, if it is more than 50 lakh. So friends, a lot of judgments which is pending in Honorable High Court also, wherein even in the case of less than 50 lakh, AO tried to inflate the figure. Instead of having less than 50 lakh, AO tried to inflate the figure and try to make it more than 50 lakh just to trigger and invoke the provision of 10 years. Challenge in a writ petition, notice issued, stay granted, matter pending. So that is the reason I'm saying every little point in the act is important. Anything missing, you have to see whether this is a fit case to challenge in a writ jurisdiction or not. Section 149, subsection 1A. It says, provides that if income escaping assessment in the form of an asset or expenditure in relation to an event or occasion of rupees 50 lakh or more is in relation to more than one assessment year within the extended period of 10 years, then notice under section 148 can be issued for every such assessment year. So instead of one, then this subsection says that notice under section 148 can be issued for every such assessment year. Now, section 149. Now, let us see what time limit prescribed under section 149 of the Act shall exclude the time or extended time allowed to the assessee to respond to the show cause notice under section 148A clause B and any period during which the proceeding under section 148 are stayed by an order of any court. Now, you have challenged something in a high court and the high court has given an interim stay in the matter. So till the time the interim stay is extended, that is a time period excluded from the limitation period. So take an example, if stay extended till 1 year, then 1 year is excluded from the time limitation for the assessing officer. Now let us see what authority, the new authority, approval of specified authority. For the purposes of section 148 and 148A, specified authority shall be where 3 years or less have elapsed from the end of the relevant assessment year. The authority specified is principal CIT, principal DIT, CIT or DIT. Where more than 3 years have elapsed from the end of the relevant assessment year, principal CCIT, principal DGIT. Friends, please see in the notice who is the sanctioning authority. That is very, very important if you have to comply, because this is also a jurisdictional point. In cases where a reassessment is initiated on the basis of deemed information, no reassessment order shall be passed by an AO below the rank of joint CIT except with the approval of additional CIT. Can we do let us quickly do a comparative, friends. I think it is more easier now as we have already covered the erstwhile law. So now, and the new law, I have discussed the matter, the slides with you. Now let us quickly see what is the comparative analysis of the old reassessment scheme and new reassessment scheme, which helps you in understanding the difference between the two. Section 147. This section is prior 1st April 2021. That is applicable till 31st March 2021. If the assessing officer has reason to believe that any income chargeable to tax has escaped assessment for any assessment, he may, subject to the provision of 140 to 153, assess or reassess such income. Now, friends, please see. This is reason to believe. Is my marking clear to everybody? So please see, reason to believe. This is very important under old law, reason to believe. See under new law, if any income chargeable to tax, starting from there, in the case of an assessee escaped assessment for any assessment year, the assessing officer may, subject to the provisions of section 148 to 153, assess or reassess such income. Friends, have you observed what is happening? Reason to believe is missing. Before making the assessment, reassessment or recomputation, before making the assessment, reassessment, recomputation under section 147, the assessing officer shall serve on the assessee a notice. Now, this is old law, friends, under section 148. So in 147, you have already seen. In 147, you have seen that reason to believe part is missing. This is very important. This completely dilutes the complete provision. Reason to believe was a big, earlier it was a big weapon in the hands of a taxpayer to challenge the matter. And this matter is also, this reason to believe has also been addressed by a lot of courts. Now, this is now missing from the new law. Let us see what is the difference between in 148. Earlier law says before making the assessment, reassessment or recomputation under section 147, the assessing officer shall serve on the assessee a notice requiring him to furnish within such period as may be specified in the notice a return of his income. Now see, subsection 2 says the assessing officer shall, before issuing any notice under this section, record his reason for doing so. It categorically says before issuing a notice, you need to record your reason for doing so. Any reason to believe should be recorded. Let us see in the new law. Before making the assessment, reassessment or recomputation and subject to the provision, the assessing officer shall serve on the assessee a notice. Please see the difference, friends. Shall serve on the assessee a notice along with a copy of the order passed if required under clause D of section 148, requiring him to furnish within such period as may be specified in such notice or return of his income. So instead of record his reason, now it is moved with along with a copy of the order passed. Reason recorded, reason to believe missing. Provided that no notice under this section shall be issued unless there is information. So reason to believe has been exchanged with information with the assessing officer, which suggests that the income chargeable to tax has escaped assessment. In the case of an SC for the relevant assessment, and the assessing officer has obtained prior approval of the specified authority to issue such notice. The amended section 147 does not use the phrase reason to believe that any income escaped assessment and rather states if any income escaped assessment. This is sensitive. This is important. Amended section 148 provides that no notice can be issued unless there is information which suggests that income escaped assessment. In the erstwhile section 148, AO was only required to record the reason for reopening before issue of notice. Now see, recording the reason to believe is missing. Let us see the comparative analysis. It is easier now after studying erstwhile law and studying the new law. Let us see the comparative. It is also easier. Now you know what is the difference in 147? So everything is common except reason to believe, record the reason, this is missing. The whole idea was to delete those lines from the provision because those lines are, it's a settled provision from the various courts also. Existence of reason to believe that income has escaped assessment necessary. Old provision says yes. New scheme says no. Requirement having prescribed information suggesting escapement of income is mandatory. Information, reason to believe is not mandatory. Reassessment initiated beyond 4 years in case where regular assessment concluded under section 143(3) of the Act. As I have already discussed, change of opinion only if failure to disclose fully and truly material facts by assessee. Permitted in case where likely escapement of income is rupees 50 lakh or more and represented in prescribed form. Inquiry and opportunity being heard to assessee before issuance of notice under section 148 of the Act. Not required in the earlier provision, it is now mandatory in the new law. Time limit for initiation of reassessment proceedings, general 4 years. Old law, where income escaping assessment exceeds 1 lakh, 6 years. General is 4 years, and where it is exceeds 1 lakh, it is 6 years, and in case of foreign asset, 16 years. This was there under the old provision. New says 3 years. In case where likely escapement of income in the form of asset, expense, or entry is rupees 50 lakh or more, 10 years, sorry. No separate category for foreign asset this time. New reassessment scheme is, as I've already discussed, friends, is based on the procedure laid down by Supreme Court in the case of Cheek and Drive Shaw. Inasmuch as AO is required to conduct preliminary inquiry, issue show cause notice to assessee affording opportunity of being heard, and thereafter pass speaking order prior to issuance of notice under section 148. Friends, no separate time limit for reassessment given this time in case of foreign income and assets. Friends, limitation in case of such cases is governed by section 153, that is dependent on financial in which notice under section 148 was served and not on the basis of such authorization as under erstwhile law. Now, we are, after discussing and analyzing the erstwhile law, new law, comparative, now we are moving, friends. What is the conflict in old law and new law? Moving towards conflict. CBDT issued several notifications extending the, if you remember when I started my slide, I have started with what happened. What was the controversy happened pan-India. I am now coming and moving to those slides. CBDT issued several notifications extending the applicability of old reassessment provisions from 31st March 21 till 30th June. In fact, it is 1st April 2021 till 30th June. Finance Act 2021 provided that the new reassessment scheme shall be effective from 1st April 2021. Notices under erstwhile reassessment scheme was issued to various assessees after 1st April 2021 without following the provision of new reassessment scheme. Due to the conflict overlap in two different reassessment schemes, notices issued under section 140 were challenged before High Court. Now, before coming to the slides, now let us go back and read, because as you need to understand slide by slide before going further. Now, as I have discussed at the time before starting my slides was, you remember government has passed an ordinance, then the Act, Relaxation Act, then via notification, government has extended the time limitations for various compliances. This particular new bill was presented in the Lok Sabha by the Honorable Finance Minister, passed by Rajya Sabha, and then finally given assent by the Honorable President of India on 28th March 2021, which says that this new scheme is applicable effective from 1st April. There was no saving provision in the Income Tax Act in regard to the erstwhile provision. Erstwhile means the old provision. Now, what happened? 31st March 2021. CBDT has the power via delegated legislation through notification and a relaxation act. But the power is only restricted to time limitation extension. Power is not to jump into the seat of a legislation. Legislation means, because obviously the law which is designed and prepared by a parliament has the more power as compared to a delegated legislation. Delegated legislation means the time limitation by the CBDT. So that is a delegated. They cannot overpower the legislation. So what they have tried to do, in the notification, they have inserted an explanation which says that the old provision is still prevail over the new provision. Now the point is, if the law is already passed by both the houses of parliament, given an assent by the president, which says that the new law is coming into picture from 1st April 2021, how, just by issuing you a circular or a notification, giving an explanation by CBDT, which is just a body, it's not a parliament has more powers to design a legislation. Can they stop the provision of the act which is coming into picture by the parliament? No. This is the issue. They have tried and they have informed the assessing officer that you still follow the old law. Then again, notification issued with the same explanation. This notification was challenged in a writ jurisdiction before various high courts. That notification is null and void, is ultra vires, no power. Delegated, a CBDT doesn't overpower what is given in the legislation. So what they are saying is that even only the power given to the CBDT is to extend the time limitation. They extend the time limitation. There is no question on that. But if as soon as you come into 1st April 2021, you are not supposed to issue 148 notice. As friends, you are aware about old law, new law comparative. So now I'm trying to merge all the information into one so that it is easier for you to understand. Very simple. Old law you know, new law you know, comparative I have discussed. Now what happened? Take an example. As soon as 1st April 2021, I'm issuing a notice. So I'm not supposed to issue notice under section 148. If I have to issue a notice, I have to issue a notice under section 148A clause B. The new law says this. What they have done, they have issued 148 under old law. So my question is, how can you issue 148? 1st April 2021, new law is also already inserted in the statute, approval given by both the houses, assent by the president, it becomes an act. How can you follow an old law? This is the litigation for these 3 months, 1st April to 30th June. Now what happened? First judgment was single judge judgment of Honorable Chhattisgarh High Court in the case of Palak Khattuja. This decision was given in favor of revenue by saying that they have the power. Now fortunately, first division bench pronounced decision on 30th September 2021 was Honorable Allahabad High Court. I'm being very fortunate that I was part of this matter before Honorable Allahabad High Court in the few leading matters. Honorable Allahabad High Court pronounced a decision. The division bench has pronounced a decision on 30th September 2021 in open court. This is reported in, I have already shared this particular decision with Arun also. Arun, you please share it with everybody after the presentation. This decision is reported in 439 ITR 1. This was a batch of 74 writs which challenged this particular thing before Honorable Allahabad High Court. Let me come directly. The revenue authorities had admitted that all the reassessment notice involved in this batch of writ petitions had been issued after the enforcement. So in this batch, everything was issued after 1st April 2021. As a fact, no jurisdiction has been assumed by the assessing authority against any of the SC under the unamended law. Hence, no time extension could be made under section all the notices. So in this case, what happened? All the notices were issued between 1st April 2021 till 30th June 2021 under old provision. The pleading taken by all the councils were that if they wanted to issue a notice, they're supposed to issue 148A clause B notice, not the old 148. Earlier it was 148. New law says no, first you need to issue 148A clause B, then I'll file my reply, and then you pass an order, 148D order along with 148, which is not done by an assessing officer. So this is the first decision which comes in the favor of an SSC. This matter was, I think, 27th, 24 days consistently. This argument was going in an open court. This was a physical hearing, not a virtual court at that time. So 27th, the argument started, 28th, 29th, and finally the court has started dictating the order from 29th, and finally they pronounced the decision on 30th. Many of the judgments was quoted before them. One of the judgment was Palak Khatuja, as I have referred. Friends, if you wanted to read, Palak Khatuja is reported in 438 ITR 622. Chhattisgarh High Court, single bench, single judge. Then many judgments were reported. These were the judgment which was reported referred before the Honorable Allahabad High Court. And then after this decision, the next court which pronounced the decision was Honorable Rajasthan High Court. This decision was pronounced by single bench of Honorable Rajasthan High Court on 25th November 2021. This is reported in 440 ITR 300. Friends, this is a batch of 474 writs. This is the finding. On writ petition against the issuance of reassessment notice under section 148 of the Act, contending that the notices were barred by limitation and that the mandatory procedure prescribed under section 148A as prescribed by Finance Act 2021 and applicable with effect from April 1, 2021, before issuance of notice under section 148 were not followed. Held, allowing the petition that the reassessment notices issued to the assessee under section 148 were quashed. All the notices were quashed because this is not as per the compliance of Finance Act 2021. And they have applied the decision of Allahabad High Court in the case of Ashok Kumar Agrawal, which is reported in 439 ITR 1. Then comes Honorable Delhi High Court. Honorable Delhi High Court started the argument on 28th September. This argument went till 31st October 2021, around a month. A month argument was going on both the sides. Lot of argument. I think this was the lengthiest in all the high courts. I think this is the lengthiest matter which was gone from both the sides. Many of the counsels argued from both the sides. This is the decision of Manmohan Kohli versus Assistant Commissioner Income Tax and another, pronounced by Division Bench on 15th December 2021. This is a batch of 1,294 writs. Reported in 441 ITR 207. I have shared this order also with Arun. I'm just coming to the finding, the relevant part. Held that admittedly the time limit to issue notice for reassessment under the Act stood expired long time ago. The legislature, by virtue, interestingly to know this thing, you need to understand a lot of by reading these judgments, you know what is constitution, what is the power. As everybody is know that there are three pillars of the constitution. Pillar one is legislation, parliament, which has the power to frame the law. Pillar two is executive, which is the bureaucracy, which executes the law. And pillar three is judiciary, which interprets the law. So when you read what is the saving clause, what does the constitution talks about, you understand what is the power. Delegated legislation means power given by the central government to a body, like in the case of income tax, that is CBDT. So the question which comes in the mind, if a law which is framed, passed by both the houses of parliament, Rajya Sabha, Lok Sabha, then passed by Rajya Sabha with some modification and then given an assent by the president, can just by issuing a direction by a CBDT, that direction overpowers and that direction gives power to the executive being one of the pillar of the constitution. Can those executive powers can overreach what is the power given to the legislation, which is the power of the law by the constitution. This income tax, not only income tax, you need to understand the constitution. So I believe many of my friends, they do GST matters. You know what was the constitution amendment done in the Indian constitution at the time of coming out with the GST amendments to bring GST into the picture. So when you read these judgments, I'm not going into detail, you learn a lot of things, what type of effort the councils has done in the matter when they were arguing these matters before the court. And there are a lot of questions which the Honorable Court has raised, because I was fortunately in all these matters, I am also part, many of my writ was there in these matters. I've seen closely how much effort we have put in, how much effort every council has put in, both the sides, from the side of assessee as well as from the side of the department. Everybody has put in every effort. I think thousands of judgments they have taken out, they have referred thousands of judgments before the courts and address the questions of the courts, and then finally the court pronounced the decision. Held that admittedly the time limit, I think my friends, I would suggest you read Manmohan Kohli, very beautifully written. If you read Manmohan Kohli, you can get to know what is a summation and all, because Manmohan Kohli has also taken Ashok Kumar Agrawal findings also into it. The held that admittedly the time limit to issue notices for reassessment under the act should expired long time ago. The legislature, by virtue of 2020 Act, had extended the time limit till 31st December 20. So TOLA has extended the time till 31st December, and then through notification they have keep extending the time limitation, and had given discretion to the executive, one of the pillar of the constitution, bureaucracy, to issue notification. In this case, CBDT, to issue notification to extend the timeline alone. However, extending the time limit or giving power to issue notification to extend the time cannot be taken to be the vested right of the respondents. It is not the vested rights. See the beautifully how it is written. The judgment is written. You appreciate the type of effort everybody has done, and based on this judgment is in your hand now. Even if it was assumed that the explanation and the two notifications were valid, the notices were bad in law, as they only sought to effectuate the erstwhile section and did not cover section 147. However, the conditions provided for in the substituted section 147 were not considered while issuing notices by the AO. In fact, section 147 itself is subject to sections 148 to 153, which would include section 148A. The legal fiction argument was without any foundation. There is no provision in the 2020 Act is, friends, Relaxation Act, TOLA, stating that if action is taken within the extended time limit, it would be deemed to have been taken before the expiry of original time limit. Consequently, the reassessment notices issued under section 148 of the Act were to be quashed. These were the judgment which was referred before the Honorable Delhi High Court from both the sides. After this, I'm being fortunate to be part of Calcutta High Court also. After this, the Calcutta High Court has, the learned single judge of the Calcutta High Court has pronounced a decision on 17 January 2022. This is reported in 441 ITR 418, batch of 133 writs. They have followed Ashok Kumar Agrawal. They have, which I have discussed, Allahabad High Court. They have followed BPIP Infra, Rajasthan High Court. They have followed Manmohan Kohli, Delhi High Court. And then they have, these were the judgment, and they have followed Palak Khatuja, which is a Chhattisgarh High Court. So before Calcutta High Court, 4 High Court has already pronounced a decision. Held allowing the petition that the explanation to the notification were ultra vires the 2028 and were therefore bad in law and null and void. All the notices issued under section 148 of the 1961 Act were quashed, with liberty to the AO to initiate fresh assessment proceedings in accordance with the provisions of section 148. Same thing which they have also mentioned. I being fortunate to be part of Bombay High Court also, Honorable Bombay High Court. This decision, the lead matter was in the case of Tata Communication Transformation Services, pronounced by Division Bench on 29 March 2022. This is reported in 443 ITR 49. This is a batch of 2053 writs. Again, many judgments were quoted in this thing, same position they have also taken. Now comes a big blow. After these decisions, Ashish, if you remember, I have mentioned in Honorable Allahabad High Court, and I being fortunate that I being part of this judgment also, in Supreme Court also. So this judgment was pronounced on 4th May 2022. So last judgment was pronounced by Honorable Bombay High Court on 29 March 2022. Ashish, if you remember, I have discussed, friends, in Allahabad High Court, there is a batch of 74 writs. So one of the writ was Ashish Agrawal. Ashish Agrawal was a small person, small writ in the matter. Instead of a lead matter, department has filed an SLP in the name of Ashish Agrawal. The leave was granted and the SLP converted to a civil appeal. This decision of Honorable Supreme Court was pronounced by Division Bench, and this is reported in 444 ITR 1. Now let us see what is the order. Now this judgment is important because, friends, one of the unique judgment wherein Article 142 of the Constitution is invoked by the Honorable Supreme Court in this matter. Very rare cases you will observe Article 142 in the tax matters. I am just reading para 2.1 of the order says applicable on all the judgments and orders passed by various high courts. So at the time of giving a decision, Honorable Supreme Court has mentioned that what is the finding they are going to give in this decision is applicable on all the judgments and order passed by various high courts in India. Let us see. They have analyzed, friends, I have already covered, but let me again come back. They have analyzed Pre-Finance Act 2021, which we have already discussed with you. Then they have analyzed Section 3. Now see what the Honorable Supreme Court has analyzed before coming to a conclusion. I have tried to make it very friendly slide for you people to understand things step by step. They have analyzed Pre-Finance Act 2021, para 3 of the order. They have analyzed Section 3 of the Relaxation Act and the notification issued, because this is also a point. This they have analyzed in para 3.1 of the order. They have analyzed substituted Section 147 to 149 and 51, which is applicable with effect from 1st April 2021, which we have also discussed, para 3.2 of the order. They have seen the contention of the revenue, para 4 of the order. Let me see what is the contention they have taken. Despite the substituted section, this is the contention of the revenue. Let us see what is the contention of the revenue before the Honorable Supreme Court. So, once you read the contention, then it is easier for you to understand why the Honorable Supreme Court has pronounced the decision. What was the logic of pronouncing that decision, based on which a second round of litigation has been started. Despite the substituted Section 147 to 151 of the Act by the Finance Act 21 coming into force on 1st April 21, friends, see, this is the number coming from the Honorable Supreme Court order. The revenue issued approximately 90,000 reassessment notices. Numbers coming from Honorable Supreme Court. 90,000 reassessment notices pan India to the respective assessees under the erstwhile Section 148 to 151 thereof. Relying on the explanation to the notification dated 31st March 21 and 27th April 21. The said reassessment notices were the subject matter of writ petition before the various high courts. The respective high court have held that all the respective assessment notices issued are bad in law, as the reassessment notices issued after are governed by the substituted sections. Consequently, the respective high courts have set aside all the reassessment notices and issued under Section 148. Friends, now let us start reading together and understand. The common judgment order passed by the High Court of Allahabad is the subject matter of present appeal. So they have challenged the Honorable Allahabad High Court order. However, the High Court of Delhi in its common judgment order dated 15 December 21, while quashing the respective reassessment notices, also observed that if the law permits the revenue to take further steps in the matter, they shall be at liberty to do so. So obviously, the High Court has to give these findings. If the revenue believes that they still have a time limitation, they can issue fresh 148 notice following the new procedure. And this is the liberty every High Court gives, because the revenue must have the liberty in case of the time permits, if the time is not barred. The Honorable Supreme Court observation about Pre-Finance Act 21 litigation grounds, let us see, which is coming from para 6 and 6.3 of the order. Pre-Finance Act litigation grounds. As we have already discussed, let us quickly see what was the understanding. No valid reason to believe, no tangible reliable material information possession, no inquiry being conducted, reopening based on change of opinion, mandatory procedure, and G can drive short. We have already read these in the earlier slides. But prior to Pre-Finance Act 2021, while reopening an assessment, the procedure of giving the reasons for reopening and an opportunity to the SC and the decision of the objectives were required to be followed as per the judgment of Honorable Supreme Court in the case of DG can drive short. We have also gone through this. Then they have analyzed in para 6.4 of the order the Post-Finance Act 2020. Friends, we have also gone through these slides earlier. However, by way of Section 148A, the procedure has now been streamlined and simplified. It provides that before issuing any notice under Section 148, the assessing officer shall conduct any inquiry if required with the approval of specified authority with respect to the information which suggests that the income chargeable to tax has escaped assessment, provide an opportunity of being heard to the SC with the prior approval of specified authority, consider the reply by the SC furnished, if any, of the response to the show cause notice, B, and decide on the basis of the material available on record, including reply of the SC as to whether or not it is a fit case to issue notice, and then AO is required to pass a specific order within the time stipulated. Now, this is the observation. Now, this is new thing, friends. Now, you just focus on the slide. This is the observation of the Honorable Supreme Court post Finance Act 2021, which is coming from para 6.5 of the order. Therefore, all the safeguards are provided before notice under section 148 of the Income Tax Act is issued. At every stage, the prior approval of specified authority is required even for conducting the inquiry as per section 148A clause A. Only in case where the assessing officer is of the opinion that before any notice is issued under section 148A clause B and an opportunity is to be given to the SC, there is requirement of conducting any inquiry. The assessing officer may do so and conduct any inquiry. Thus, if the assessing officer is of the opinion that any inquiry is required, the assessing officer can do so, however, with the prior approval of specified authority with respect to the information which suggests that the income chargeable to tax has escaped assessment. Para 7 of the order, again the observation. Thus, the new provision substituted by the Finance Act 2021 being remedial and benevolent in nature and substituted with specific aim and object to protect the rights and interests of the SC, as well as when the same is being in public interest, the respective High Court have rightly held that the benefit of new provision shall be made available, even in respect of the proceedings relating to past assessment years, provided section 148 notice has been issued on or after 1st April 2021. So, the Honorable Supreme Court has put in a stamp on this point and confirmed that the whatever be the findings of the Honorable High Court is correct. The respective High Court have rightly, so they have confirmed that the position taken by various High Court is correct. Now the question comes, if it is correct, then why Article 142? Let us see. However, at the same time, the judgment of several High Court would result in no reassessment proceeding at all, even if the same are permissible under the Finance Act 21 and as per substituted section so. So what they are saying is that based as the notices have already been caused, now under the new law also the assessing officer time limitation has already been part. They lose that. Obviously, the revenue will lose a lot of revenue. The revenue cannot be made remedialist and the object and purpose of reassessment proceeding cannot be frustrated. It is true that due to bona fide mistake, and in view of subsequent extension of time by various notification, the revenue issued the impugned notices under section 148 after the amendment was enforced with effect from 1st April 2021 under the unamended section 148. In our view, the same ought not to have been issued under the unamended act and ought to have been issued under the substituted provisions of section 147 to 151 of the act. As per Finance Act 21, there appears to be a genuine non-application of the amendment as the officers of the revenue may have been under a bona fide belief that the amendment may not yet have been. See, these were the reasons why 142 has been invoked, article. However, at the same time, the judgment of several High Court would result in no, Then para 8 and 10 of the order. Therefore, now this is the finding. We propose to modify the judgments and order passed by the respective High Court as under. The respective impugned section 148 notice issued to the respective SC shall be deemed to have been issued under section 148A of the IT Act. So what they are saying, so the earlier notice which was issued in between 1st April 2021 to 30th June, instead of 148, you read it as 148 clause B under the new. So replace 148 with 148B. You treat it as a show cause notice under the new law. The respective assessing officer shall within 30 days from today. So 4th May 2022, they have pronounced, they have given 30 days and informed that till 2nd June 2022, assessing officer is supposed to provide all the information and material relied on by the revenue to the SC so that they can file a reply under section 148A provision, and that too within 2 weeks. The requirement, so they have for these matters, they have dispensed with the requirement of 148 clause A. 148 is small a, they have requires, and that those notices which have been issued under section 148, including those which have been caused by the High Court. So what happened, out of 90,000 notices, around 9 to 10,000 people were there before in the litigation, or maybe 14,000. Balance were not before the litigation. Even in smaller cities, many were not aware even that these notices the people are challenging, the lawyers are challenging in a High Court. So out of 90,000, you consider that around 15 to 20% were the only challenge in a High Court. Rest 80% still pending. They have not challenged in a High Court. That is the reason the court says those notices, whether they have been caused or not caused, they are supposed to follow these rules. Even otherwise, as observed here and above, holding any inquiry with the prior approval of specified authority is not mandatory, but it is for the concerned assessing officer to hold any inquiry if required. Now, then the assessing officer shall thereafter pass an order as required under section 148D. This is the reason of this another round of litigation. All the defenses which may be available to the assessee under section 149 and which may be available in the Finance Act and in law, and whatever rights are available to the assessing officer are kept open and shall continue to be available. So this has a different level of interpretation by the revenue and by the assessee. The present order shall substitute, modify respective judgments, irrespective whether they have been assailed before this court or not. So they have categorically mentioned whether you have challenged or not, this particular decision is applicable pan-India. Now, this is the reasoning given by the Supreme Court. We are also of the opinion that if the aforesaid order is passed, it will strike a balance between the rights of the revenue as well as the respective SC, as because a bona fide belief of the officer of the revenue in issuing approximately 90,000 such notices, the revenue may not suffer, as ultimately it is a public exchequer which would suffer. Therefore, we have proposed to pass the present order with a view avoiding filing of further appeals before this court and burden this court with approximately 9,000 appeal against a similar judgment in order passed by various high court, the particulars of some of which are referred to herein below. They have categorically mentioned no need to file any other appeal. Apply this judgment pan-India in whatever the matter which is pending or which has already been pronounced by High Court. Now, we have also proposed to pass the aforesaid order in exercise of a power under Article 142 of the Constitution of India by holding that the present order shall govern not only the impugned judgment and order passed by High Court of Judicature at Allahabad, but shall also be made applicable in respect of similar judgments and order passed by various High Court across the country. And therefore, the present order shall be applicable to pan-India. So they have categorically mentioned this order is applicable pan-India. Supreme Court order applicability is given in para 11 of the order. This is the applicability. The present order shall be applicable pan-India in all judgments and orders passed by different high courts on the issue and under which similar notices which were issued after 1st April 21 issued under section itna set aside and shall be governed by the present order and shall stand modified. Pending writ petition pending before various high court in which similar notices under section act issued are under challenge. So after this judgment 4th May, what happened? The CBDT has issued a circular because the officers were confused and that was a different interpretation of the CBDT in that circular. Wherein, now friends, what happened? If you read 149 time limitation, which categorically talks about that if at the time of coming this new law into picture, if some law has already been time barred, some year has already been time barred under the old law, it is time barred. So if you remember under old law, assessment 13-14 was supposed to time barred on 31st March 2020, 6 years. Assessment 14-15 was supposed to be time barred on 31st March 2021. So 13-14, 14-15 was supposed to be time barred. But based on this CBDT note, though the Honorable Supreme Court has categorically mentioned that all the defenses are open, in spite of that, the CBDT by this circular has opened the Pandora box and given a power to the assessing officer following this circular that you still open 13, 14, 14, 15, which was not the intention of the Honorable Supreme Court. And based on that circular, they have opened that Pandora box also. These matters were pending. 13, 14, 14, on 13, 14 issues, Honorable Delhi High Court Division Bench has already pronounced a decision against the assessee in favor of revenue. This issue was challenged before Honorable Supreme Court, wherein the SLP has already been dismissed on 11th April 2023. In limine dismissed without going into the merits. Then, on a similar findings, Allahabad High Court has given a positive decision in the case of Rajiv Bansal. Gujarat High Court has given a positive decision in favor of taxpayer. And against that Allahabad High Court, revenue has filed an SLP which is pending in Supreme Court. Notice has already been issued and the stay has been granted on the Honorable Allahabad High Court decision as well as on Gujarat High Court decision as well as on Rajasthan High Court decision. This matter is pending regarding to 13, 14, 14, 15. Now friends, what happened? After that decision of Supreme Court, they have started issuing notices. People have filed reply. They have passed an order. Against that order, many of them have already moved before jurisdictional high court. Like in one of the cases wherein I have addressed that Minu Shopla 445 ITI 0001. This decision was post Honorable Supreme Court decision. That is the reason I have mentioned that 27 May 2022 was the date of pronouncement of the order by the Honorable Delhi High Court. So Everything was done in the new second round of litigation. You moved and they have passed it. Then Popular Medicos, same thing, reply not considered. So another round of controversy has started after the Supreme Court decision. And till date, many of the litigation, many of the things are going on. So this is all about 148, 147. And I'm very happy that all the people are very patiently hearing everything. Now the time comes to address your queries if you have any questions. We have already covered, again I'm repeating, we have already covered erstwhile law. We have covered the new law. We have covered the comparative between the old law and the new law. We have covered the findings of the different high court like Chhattisgarh High Court, Palak Khattuja, Allahabad High Court, Ashok Kumar Agarwal, Rajasthan High Court, BP Infra, Calcutta High Court, Manoj Jain, Delhi High Court, Manmohan Kohli, Bombay High Court, Tata Communication, followed by Honorable Supreme Court in the case of Ashish Agrawal, and then second round of litigation which is going on. This is all about 148. Yes, now in case if any of my friends have any questions, time to address your queries. So Arun and Pooja, please let me know if somebody has any query, if I can, I'll attempt to address the queries. Thank you so much.
Sure, sir. So member अगर कोई query है तो आप please raise कीजिए hand. Income tax के regard में कोई भी query, मतलब if you have any query, you can raise your hand. I can unmute and you can ask the question directly to sir.
I'm very happy that I have covered my 152 slides in a time limitation.
Thank you, sir. So any participant. So sir, means we educating basically what we are doing along with regular work which we are doing. See, we have the membership concept in the GST since 5 years. We have launched this membership in the Feb 2018. So what is that? We are providing the queries resolution over the WhatsApp group, and we are covering the multiple webinars on like recent amendment or like some other speaker. We are talking about GST litigation, notices, etc. And apart from that, so only tax consultant are having the support to review the GST notice. Suppose someone has drafted the notice. So with our limited knowledge, we are supporting in reviewing the notices reply to the tax consultant. That is 5. So as of now, we are having the total 500 plus members pan-India in the GST. On the similar line, in the last month, we have launched the income tax membership. And in this next month, September, we are launching the PF and ESIC membership for supporting the litigation in the PF and ESIC. So this is the some sort of background of the educating. So I will like to meet personally to you, sir. मैं आपको बताता हूँ, sir. Whenever I got a chance to that location, so मैं आपको personally message करूँगा and will try to meet with you.
Definitely, Arun. Definitely. Anybody has any questions?
So I think, sir, अभी थोड़ी strength, जैसा कि मैंने आपको कहा था कि sir, currently because we have recently launched the income tax membership, so quantum is comparatively less. So in future, gradually it will also be increased, and then we will enjoy too much comparatively. So I think there is no question from the member. Let me wait only for 2 minutes, sir.
Sure, Arun. I'm happy that we have covered prior to our time. We have already saved 15 minutes of our time.
Okay, sir. Mahendra Jain.
So I tried to give 15 minutes for the, I think Mahendra ji has some questions.
Correct. So, I think, wait. Mahendra ji, can you unmute yourself?
Yeah. Hello, can you hear me? Hello.
हाँ, आवाज आ रही है. एक पूछिए, आप अपना query पूछिए, sir.
Sir, in case of one my SSC for financial year 2016, the reassessment was done, and at that time there was argument was that as a DDIT as a conductor.
Sir, reassessment notice कब issue हुआ आपको?
For financial year 15-16.
हाँ sir.
Financial year 15-16.
Financial year 15-16 means assessment year 16-17.
Correct. At that time,
yes sir.
And their argument was that DDIT has conducted some audit, and on that basis they found some transaction as bogus or fictitious.
आपका this 16-17 was already gone through original assessment earlier, or is it only intimation then after 143(1) and then after 148?
No. My question was what that at that time that reassessment was completed and without any addition, the order was passed. Right? And again now further for same manager again they opened reassessment same. So can they?
So 148 has already been done, and again they are issuing 148
for same year. And now the argument was same DDIT, same everything for year is same. And they now transaction they change, amount they change.
No, sir. If what I understand, if it is same.
Hmm.
So earlier, when they have issued your notice, like one original assessment was already completed. 148 was when completed earlier order
Last year.
last year, and within a year also they have issued you another notice.
Yeah. In March, before this 31 March, again they issue new notice for same year.
So have you informed them? You already have original assessment records. You discuss with him whatever the query you have already addressed. Inform them this is the query already addressed, and based on this, the assessing officer has already been satisfied and they passed an order. So this is a case of change of opinion or review of the order. This is not acceptable until they don't have a fresh material. If they have a fresh material, maybe in subsequent assessment, if they have received some fresh material, then definitely yes, they can come out and issue your 148. There is no restriction on issuing 148, but every time they have to come out with a fresh material. They cannot issue 148 on the same material.
My argument is same DDIT, same they have conducted audit on, they found some transactions. Year was same. So again they came some new transaction. The year will be same at that time. DDIT is conducted.
So sir, you take all these points when you are responding to your 148 clause B show cause notice. At the time of filing your reply, address all those points there.
Okay, sir. Thank you, sir.
And in case if they are not addressing your objection, disposing your objection properly, then challenge it in a jurisdictional high court, in a writ jurisdiction.
Because at that time I also thought to go to High Court, but somebody suggested don't go to High Court, because if you go to High Court and by chance High Court has not listened, then the department not leave you and they will.
No. So whatever the rights and remedies is available, these is the try to understand, Mahendraji. This is the time of faceless. Okay. This is not the time wherein you are being very afraid of your assessing officer. If the remedy is given in the statute, you have to comply. Why so many writ petitions people are filing? I have a lot of decisions wherein we have raised those issues and the court has given an address those issues. So what I understand based on the limited facts which you are telling, if the same material, based on the same material, again they are issuing
only
148.
Only amount change now. So they found some new transaction, but audit, same DDIT has conducted that audit and they found some transaction, one lot. And now they're saying the different lot. But everything is facts is same.
So it's okay, sir. Then you can challenge. I'm not sure whether the assessment has already been completed.
Yeah, for that 50-60 already on reassessment and it was nil order.
Ordered, no? It was a nil order.
And again same year they reopened for same year. And now
why I'm saying again a same year, the second assessment, is it still going or order has already been passed?
It's going now, just your reply. 148.
No, you have responded. Are they complying with 142 and 143 too?
No, they are still they ask for further details. They have not listened to us.
So if what is the jurisdiction? You still have a time period. You challenge it. If you still have a time, they have not passed in order. Once they pass an order, then it is difficult for you to challenge. If they have not passed in order, if the time is not passed much, challenge it in a high court.
Okay, you are eligible to go to high court according to you.
Okay. Depending on the facts, then you have to show the papers. Based on the papers, only a person can suggest whether this is a fit case for high court or not in a writ.
Can I send the query on this next time? Can I send you the paper?
Sir, not the paper, sir. I would suggest if this is the only query, whenever you wanted to go for a writ, then you can consult somebody. Okay. Whosoever you wanted to consult, they need to see the papers and then only can address you whether you can go in a writ or not. Yeah. But what my understanding based on the limited fact which you are telling me, I think this is a good case for a writ, subject to the papers.
Okay. So if I want to contact them, can I contact for this case?
So you can contact Advocating. In turn, they will discuss with us, sir, and they will reply based on what is the outcome. So we cannot give the opinion or something like that. We cannot say that whether it is fit or not. Whatever the point of the sir, that will be communicated to you.
Thank you so much, sir. Okay.
Thank you. Thank you.
So I think there is no more query, and let me give the vote of thanks on behalf of Advocating. I would like to take a brief moment to express our heartful gratitude to our esteemed income tax faculties, sir ka in-depth knowledge, commitment to the teaching, and unwavering patience has really made this particular webinar wonderful. Even I myself, because of the 4 to 5, there is one class which I took, but after 5, I was continuously sitting to understand the discussion which sir was having. So thank you very much, sir. And in future, we will ensure our maximum participation from Advocating members, and thanking once again to giving your valuable time to the Advocating platform.
Thank you so much, Arun. Thank you, Pooja. Thank you all the members. Thank you so much for your patient listening. I hope I have addressed I have cleared all your doubts. Thank you so much. And thank you
Okay.
educating. Thank you.